Hello, everyone. Today I'm going to talk about an important case that just came down August 3rd, 2022, dealing with condemnation and property takings in the context of a utility. And this is a really important case. It's an Indiana case. It deals with Duke Energy Indiana, LLC. And the court goes through quite a bit of discussion on when is a taking occur, what is it, what are the factors to consider, and that kind of a thing. And I'm going to try to just be a summary on it, but the key issue here is that we've got Duke Energy is not the state of Indiana, right? Normally we think of a taking being the state of Indiana taking your property to build a road, for instance. That's the most common example that we see. There's a road widening, or the city or the state purchases or wants your property for a park or some other public purpose. That's the main thing. And whenever the government takes our land under the Fifth Amendment and also under the Indiana Constitution, the analysis is the same. The words are slightly different, but it's the same idea. If the government takes your land, you have to be compensated accordingly. We litigate this kind of thing on a fairly regular basis, and it's quite interesting and quite fact sensitive. In this case, it's important because Duke Energy is not the state of Indiana, and so what was at issue is an easement, and the width of that easement is governed by, of course, your deed to your property. And also what came into play was a regulation governing utilities on the distance between a building and a utility line. And it's there's a bit of a conflict, right? So in this case, there's a 10-foot wide utility easement, pretty common, right? So you'd see that on your Alta survey, and it'd come up on your title work, right? And this company bought a piece of ground at 1.17 acres. It had a building on it, and later they wanted to expand the building, and they hired an architect, and the architect missed the reg. They saw the easement on the survey, but the easement was 10 foot wide, and the regulation for the utility was 12 and a half feet wide. So you couldn't build anything within 12 and a half feet of the utility line, and this building, this new warehouse little building, would have encroached into that area, even though it wouldn't have encroached into the 10-foot utility easement. So the property owner alleged that they had a taking of their property because of this regulatory 12 and a half foot wide area, and they alleged that Duke actually physically reduced the size of their warehouse by 150 square feet according to what had happened, according to the easement and according to the regs. So whenever you buy property, of course, you've got to be sure that you know where the easements are, and you have to be super careful about these regs because the regs are deemed to be known to you as a buyer. And even if they're not of record, it's kind of weird. These regs are they're not easy to find, and the architect missed it. So the court was not persuaded that there was any kind of a taking. They said, look, the regulatory aspect of a taking is possible. So there's a physical taking. If you take the ground, right, that would be a true taking. Or there can be a taking of your property by over-regulation, or the regulation burdening the property so much, right? But the Court of Appeals, had gone up and down in the courts, decided against the property owner and said, look, you should have known the regs when you bought the building. You haven't proven any evidence of actual economic loss. Wow. Right? So after all the proceedings, and it went up to the Supreme Court, back to the trial court, back up to the Court of Appeals, no record of evidence of what the economic loss was. And the Court of Appeals said, look, you lost 150 square feet on your building, but you didn't show that really impaired you much. And if it was de minimis. and you lost one rack of storage, you went from 30 to 29, we still don't know if there's any economic loss there, according to the Court of Appeals, even though it's a little bit smaller building. So they really focused on you should have known the regs. A regulatory taking affected all property owners because of this 12-foot wide, 12.5-foot wide requirement. It wasn't a specific regulation that only impaired the property owner. So they had to say, look, it's a public health and safety issue to make sure that we don't build things too close to a power line and we don't electrocute ourselves, cause fires, damage to property, people get hurt or die. And so the court went through all this analysis and just said, no, in this case, it's very fact sensitive, but in this fact pattern, there's no regulatory taking. And I want to hit a couple of quick points as well. I want to come back to this because the court is pretty strong in what it decides is an inverse condemnation and the requirements. I want to give you those so that you've got them. Number one, there's a taking or damage of private property for public use without just compensation by a government entity that has not instituted formal proceedings, right? So 5 elements, and they went through all of that. And the government regulation can, in some instances, be so onerous that its effect is tantamount to a direct appropriation or ouster, and that can be a regulatory taking under the Fifth Amendment or under the Indiana Constitution. Just repeating some of that I talked about. I want to come back to a couple more points. Supreme Court, United States Supreme Court addressed this regulatory taking in the Lingle decision, and it said, where government requires an owner to suffer a permanent physical invasion of their property and regulations that completely deprive an owner of all economical beneficial use of our property. All, right? So those are pretty broad. Now the court walks it back and looks at some of the decisions that came after that, Penn Central and some others, and it walks back this idea of complete loss economically. But again, going back to my earlier comments, Court of Appeal said, look, you haven't even shown any evidence. You've presented zero evidence of economic loss. So the court really looked at that factor as a strong one, and the de minimis nature of what happened, the fact that the owner of the property bought it without any kind of particular investment background to the purchase, right? The investment aspect of the purchase was not hinging on expanding this warehouse for its future use. So the Court of Appeals is like, look, when you bought this, you didn't even intend to increase the size of your warehouse. You didn't intend any new buildings. You knew about the easement. You should have known about the regs, even though you didn't, right? Or even though you didn't look it up. It just looked at it and said, look, there's just not enough here. So inverse condemnation is what we're talking about. Regulatory takings, these are huge. I note that I think there's some litigation pending now against the governor for the eviction bans that occurred as well. We had that federal court case that the eviction ban was ended within 2 days of our filing of that suit. Now there's some new litigation trying to recover sort of on a class action basis or for various plaintiffs that are pursuing that. So we'll see how this plays out, because I'm sure the same analysis is going to play out in that matter, and we'll see what the emergency powers of the governor have to do with that, and whether the Court of Appeals and the Supreme Court of Indiana will determine that the Constitution is suspended during each state of emergencies or not. That's going to be a key issue, and we haven't had to address it in a long time. So I look forward to keeping you informed about this, and I hope you've enjoyed it and found it helpful. If you need to litigate a condemnation case, we'd be happy to help you. Thank you.